Welcome to Part 3, Business Auto, Focus on Liability. If you have questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar by email. If you experience any audio problems, please send us a note in the chat window or call us at 800-741-4084. We will attempt to correct the problem as soon as possible. The previous 2-hour session addressed the importance of making sure you list the correct named insured on the named insured line. Find out and list the business whose assets the business auto policy are going to protect in Item 1 of the deck. Any legal entity listed in Item 1 will meet the definition of you in the coverage form. It could be a corporation, LLC, partnership, or an individual, the legal entities of the business. There's no need to list the owners, partners, managers of these legal entities in Item 1 of the deck. They're already covered. Second thing, to have the policy respond properly, you must make sure the crash was happening by, the accident was happening by a covered auto. To have the policy respond, the auto that was involved in the accident must meet the definition of covered auto, or the policy will not respond. This is the two important steps to make sure the insurance liability is properly covered. Do we name the right business, and do we have the covered autos that ensure to be used to be considered a covered auto? We looked at who is an insured. You, that's the legal entity on the deck sheet, any legal entity on the deck sheet, but only for a covered auto. Permissive user, any other who operates a covered auto with permission from the you, the entity, the business listed on the deck sheet. Customers and owners of the entities are already covered because the policy contains in the who's insured provision blanket additional insured. It states anyone listed in for the conduct of an insured is an insured for that vicarious liability exposure. So that is already covered. We don't have to list them. They're automatically covered. But not the owners of the covered auto. The insured to you has coverage, but not the owners without adding an endorsement. The CA 9947 would be covered for the vehicle is owned personally by the owner of the legal entity, but the legal entity is insuring. That is employee as lessor. CA 201 is the additional insured to lessor, and loss payee, that's for the long-term finance leases with PACCAR, Penske, or Ryder. CA 9916 is the hide car specified as owners. That is the endorsement that you would add in our industry, an owner-operator to the policy where we schedule the vehicle the policy. Those three convert the non-owned auto to an owned auto to make coverage primary and covers the liability of the owner, but only for owning the vehicle. CA 9916, employee as additional insured, that is in excess of the employee's individual policy. That would be used if your business has employees that operate a personal vehicle, someone going to get the mail, someone going to get lunch. And the trucking industry and the auto commercial industry, it'd be a mechanic who has their own pickup truck, could be a sales rep, anybody like that. Their personal auto policy will respond first, and then if their personal auto policy did not settle the suit and your insured is named in the suit, the business that we're insuring is named in the suit, then they could be held responsible for the actions of these employees. If it's a business-related activity, even though it's in the personal vehicle of the employee. Again, the employee's policy would respond first, and then we would cover the employee as well as the business in excess of the auto policy on the vehicle of the employee. That's CA 9933. Protection for you insured rising out of their auto exposure is addressed by the use of the auto coverage form. Because if the insured gets sued, do they expect the insurance policy and agent to provide them protection for these suits? The trigger of coverage being provided correctly to always meet the insured's expectations. That is, the vehicles that will be considered a covered auto, and explaining those to the insured. The liability policy will respond if the insurance applies. If not, then excluded. And so let's look at exclusion. Exclusion 1. This insurance does not apply to any of the following: expected or intended. This auto policy excludes policies expected or intended from the standpoint of the insured. That's a GL exposure. So if your insured intended to run down somebody, that would not be auto. It would not also be covered under the GL. But if the insured attempts to protect the cargo, then the auto policy would not respond. That would be the GL. For example, one of my clients, when I teach a class, I always call them my favorite client, which is a beer distributor, Fort Myers, Florida, Mark V distributors. There was a time where one of their employees was delivering beer on Fort Myers Beach. Someone came and took a case off of their truck as the driver was inside delivering their handler truck full of beer. When the driver came back, they saw this person with this case, and they got the case back. The person who got the case, the person who they got it back from, didn't look the same. I contend that they were ugly to start with. They're still ugly now, but anyway, that would not be covered in auto. That would be covered in the general liability under the protection of the extended bodily injury, where the expected or intended exclusion does not apply to reasonable force to protect persons or property. But the auto policy does not cover that. Exclusion 2. We exclude liability assumed under any contract or agreement, but this exclusion does not apply to liability for damage assumed in a contract or agreement that is an insured contract, provided the bodily injury property damage occurs subsequent to the execution of the contract or agreement, or that the insured would have been absence of contract or agreement. So we exclude contractual except for insured contracts. Then we have to go back to the Section 5 of the business auto policy for the definition of insured contract. The definition of insured contract contains the 3 miscellaneous: leases of premise, sidetrack agreement, assessments of license agreement except in connection, construction or demolition operation or within 50 feet of a railroad. That's railroad protected. An obligation as required by ordinance or indemnification, a municipality except in connection with work for a municipality. Then we have 5. That's broad form contractual. That part of any other contract agreement pertaining to your business, including identification of a municipality in connection with work performed by a municipality, under which you assume the tort liability of another to pay for bodily injury property damage to a third party or organization. Tort liability means a liability that would be imposed by law in the absence of any contract or agreement. That is harder to discuss in the, or bring examples up in the auto arena. It's very relevant in GL, where our insured holds people harmless for going on their premises. This would, in the arena that we're dealing with, this would be if our insured holds a shipper or someone who loads their truck harmless for their liability arising for the person who loaded the vehicle arising out of them misloading it, and during a movement of that freight, the load that someone else put on the truck shifted or fell off and damaged the public or even damaged our driver. What this says is that if we agreed to hold them harmless even for the person who loaded the truck's negligence, then we would have to honor it under contractual. Again, it's not relevant often in auto liability because most of the time the driver is the negligent party. Other people involved are very rare in an auto crash, but it would be where our insureds hold their customer harmless for both for all relationships with that customer. And if it's an auto accident caused by the customer's negligence, then we would have to honor that contractual. We also exclude we also cover as an insured contract going on Part 6. that part of any contract agreement and enter into as part of your business pertaining to the rental or lease by you or any of your employees or any auto. That is where if we have the lease agreements that they sign and we agree to hold the owner vehicle harmless. However, such contract agreement shall not be considered an insured contract to the extent that it obligates you or any of your employees to pay for property damage to any auto rented or leased by you or any of you. This is where your insured could be held liable for loss of use of that damaged vehicle. We buy that back often with leasing companies, or those are options where we can buy back that loss of use. We could also cover that under the some endorsements we can add to this policy later. And then insured contract does not include any contract agreement that identifies a railroad. That's railroad protective. B, that pertains to your loan or lease rental of an auto to you or any of your employees if the auto is loaned, leased, or rented with a driver. That's the owner-operators agreements, or independent contractors agreements that trucking companies enter into. We do not cover the owner-operators, the independent contractors agreement, and the whole harmless agreements in those. Those are addressed by the auto liability form, and in that case, we would use the motor carrier's coverage form to address that liability. That holds a person engaged in the business of transportation property by auto for hire harmless. Again, that's if you are insured, signs agreements to hold the truck, anybody working on their behalf harmless. We do not cover those either. Again, that is covered in some places in GL and some by waiver of subrogation and some by the independent contracts agreement. So basically, the contract there's no coverage for bodily property damage where insurance does not apply. Does not apply if no coverage for expected or intended injuries, knowledge of the insured. No coverage for liability assumed in a contract, except if the contract under an insured contract. Therefore, there is coverage for insured contracts. And then the definition of insured contract contains the miscellaneous, but you have the broad form. The broad form is contracts that even have our insured holding their customer harmless, and we will have to honor those. The three that are not covered are the ones involving railroad protective and the owner-operator agreements and the whole harmless agreements with shippers involving transportation. The broad form where we do hold we do provide protection under the whole harmless agreements for the negligence of our customers would obligate us to address under the contractual, even though the additional insured would not cover that, under the contractual, their negligence. But you need to be aware in this area there are states involving in transportation that says when a customer requires the motor carrier to hold the customer harmless for the customer's negligence, that's against public policy. In other words, those contracts are not enforceable. They're called anti-indemnity statutes, which is against public policy. Every state except Mississippi, Ohio, Delaware, New York, New Jersey, Rhode Island, Vermont, and New Hampshire will be without or do not have an anti-indemnification law. All other states have it. So the whole harmless agreement in trucking, particularly as it pertains to GL, because it would apply to, but also trucking, where our insureds hold their customer harmless even for the customer's negligence, except for those listed states, would not be enforceable. Exclusion 3, work comp. Again, we don't duplicate. Either comp pays, which extends toward immunity to the insured, therefore we don't pay comp. Employee identification, employee liability, that's exclusion 4. We exclude bodily injury to an employee of the insured rising out of and in the course of employment by the insured, or performing the duties related to the conduct of the insured's business. So work comp provides a tort immunity. And when we have comp in place, that employee cannot sue. However, there are some situations where the insured is in states where work comp is not mandatory for all employees, like in Florida and North Carolina and a few other states. You have to have a numerical number before work comp is mandatory. In the states where work comp is mandatory, then the insured has to have comp, or they're fined and put out of business. Where you have a numerical number that says unless you have X number of employees, that provision, that requirement of the state to have work comp is waived. And so in those cases, we have numbers of people with vehicles or businesses with commercial auto exposure who have only 1 or 2 units, like in Florida or North Carolina or a number of other states. So work comp is not mandatory, and they choose not to have comp. But that employee could still be hurt. For example, if the vehicle has bad tires on it, the employee tells the owner, my truck that you furnished to me, my pickup truck you furnished to me has these bad tires or bad brakes. You need to fix them. I'm going to have a crash if you don't do it. The employer says, well, we'll take care of it later. We don't have enough money to do it now. Go ahead and run another day or two, and then I'll put it in the shop. And if the crash happens, that employee gets injured, they would want their injuries paid for. If work comp was in place, then work comp would address that claim, and that employee cannot sue. But since the employee still is seeking payment for that, they would sue their insured, and that insured has absolutely no coverage because they're still an employee. That's a concern that we have. If you, in our industry, use something called occupational accident policy, again, that's not work comp. Even if that employee had an OCAC policy, then the OCAC would pay, but the employee could still sue under tort, and there'd still be no coverage here, and your insured would be then bare of any protection because they're still an employee. But it's only employee. It's not independent contractors. So if the independent contractor gets hurt and the insurer's negligence, we'd have to respond to the independent contractor suit involved in the auto crash. If they get hurt, we'd have to respond to them if our insured is negligent, because again, it only includes employees. So it would exclude employees even when work comp's mandatory or not mandatory, even though the state does not require comp. The employee gets hurt, the employee can still sue. They have to prove negligence. You have no tort immunity, and so the auto policy would not respond. So the business would be subject to having that employee own the business. Second is, even if they have an OCAC policy, that's not work comp. If the employee still sues because there's no tort immunity, then again, you have the same exposure. However, if the contractor sue, this does not include independent contractors. The policy would have to respond. Second part of this, we also include the spouse, child, parent, brother, or sister of the employee as a consequence of the above, meaning there's no coverage. This exclusion applies whether the insured may be liable as employer or any other capacity, and to any obligation to such damages with or repay someone else's who must pay damage because of that injury. Again, work comp covers this. This is consequential damage. This is the loss of consortium, loss of income, those kind of things. If they're an employee, we don't respond to not only the employee themselves, but anybody else who was dependent on the employee for benefits. We would not respond to that. But this exclusion does not apply to bodily injury to domestic employees not entitled to work comp benefits or to, and here's the key, liability assumed by the insured under an insured contract. For the purpose of the coverage form, a domestic employee is a person engaged in household and domestic work performed principally in connection with residential premises, which would not come in play often, if it ever, in auto. But the second provision, it would. What it's saying here, if you're insured has a employee on a customer's premises, and it would have to be auto related. Let's say they were unloading the truck. That's still operation with auto. That load falls onto the employee because the customer's employee took the chains off, causing the pipes to fall on top of our employee. There'd be no coverage for the employee under, they would be, the employee would be covered on work comp, but they could seek a suit against the customer because that customer's employee caused that injury, and it was auto-related because it was involved in the loading and unloading of the vehicle. Since our insured held the customer harmless, even for the customer's negligence, then we might have that case come back to our auto liability form. That's why that anti-indemnification stage is so important. If not, we would have to respond. But if the contract was in any other states except the states that we listed before, then we would have to respond, and auto liability would address that and pay for even the customer's negligence under the contractual hold harmless agreement in any other state, in the states that we listed. If it's one of the states that has an anti-indemnification agreement, then even though the customer requires our insurers to hold them harmless, we would not have to respond because it's against public policy. So that's the key part here. Fellow employee, again, work comp covers them. The work comp immunity extends to fellow employees, so we do not cover them for their injury under auto liability. Exclusion 6, care, cost, and control. We don't cover property to or cover pollution, cost, and expense involving property owned or transported by the insured or in the insured's care, cost, and control. This exclusion does not apply to liability assumed under sidetrack agreement. Again, that would not be auto-related. What we're talking about here is the cargo policy. So our insured buys cargo when they're a for-hire trucker that cover the legal liability for having cargo in their possession, care, custody, or control, and they damage that cargo. Then the cargo policy, which is the Bailey form, would address that exposure, not the auto liability form. Same thing here. Also, if you're insured borrows or leases or rents a vehicle from somebody else, they damage that vehicle. That would be, they could be responsible for damage to the vehicle. We don't cover it under contractual because that was an exception 6 under insured contracts, and we don't cover them under care, cost, control. So this is where you insured would need hired car or non-hired car physical damage coverage to cover those vehicles leased, rented, or borrowed from a physical damage standpoint to buy that back. So we have cargo and we have other people's vehicles in the insured's care, custody, control. That's not an auto liability exposure. That is a Bailey exposure, cargo, or direct coverage for the hired car physical damage. So you tell the insured to purchase another policy to cover these. Business auto does not. Care, custody, control, cargo, symbol 8 for physical damage, covering non-owned autos in insured's possession or trailers or their power units or their non-owned trailers. Exclusion 7, handling of property. First off, everything that's excluded here is covered in a GL. This is where the GL policy and auto policy works together for handling of property. What we're talking about in realistic terms is the loading and unloading. The auto policy says we exclude bodily injury property damage resulting from the handling of property before it is moved from the place where it's accepted by the insured, or movement into or onto a covered auto, or after it is moved from the covered auto to the place where it's finally delivered by the insured. And so we have the loading and unloading exposure, and we have to, again, coordinate that GL. So the first consideration is make sure the insured also has GL. This is the biggest exposure. So let's look at a couple examples. The insured raises horses. They're taking a horse to a racetrack. They have to take the horse to the barn. They have to take the horse to the barn. As they lead the horse out of the trailer to take it to the barn as required, they have the bridle and they take it to the barn. The horse bolts and hurts people watching. There is injuries to the people. GL or auto. This is a question for CE purposes. Is the damage to the horse as our insureds are unloading the horse with that lead rope into the barn? and that horse bolts hurting people before they get it to the barn. Is that an auto exposure or GL exposure? Type in, if it's GL, put 1 in the chat window. If it's auto, put 2 in the chat window. I'll give you some time to think about it. Okay, let's look at it in depth. Definition of coverage between GL and business auto. Handling of property. Define coverage for damage to the public, not damage to the cargo, not what's being loaded and unloaded. That is damage to the, as covered under cargo forms that would cover those. Is protection for bodily injury property damage done during the loading and unloading of cargo from a covered auto. Damage done during the complete loading and unloading operation only. It excludes in the auto form before and after the move. So during the movement, it's not excluded, meaning that when our insurer first touches it, till they put it on their truck, till they run it, take it down the highway, till they stop the truck and deliver it and take it to the final destination, that is not excluded. That is covered under auto form. Before they touch it is GL, and after they take it to the final destination and then don't properly handle it, then that becomes GL again. And then if what's excluded here is covered under the exclusion G, or not excluded under exclusion G in the GL in the loading and unloading. The key part is to the final place of loading and unloading. So we also have exclusion, movement of property by mechanical device. Bodily injury property resulting from the movement of property by mechanical device is excluded, unless it's a hand truck, or unless the device is attached to the covered auto. What's a hand truck? We've seen most of those sitting on the front of a beverage deliverer where you have the hand truck. You often run into that, but also a hand truck can be a wheelbarrow. It can be a non-motorized pallet jack. It can be anything that can be handled by hand, have to help load and unload. One of the examples I have, we've all checked in the hotels where we use that cart to unload our luggage on that cart. That's a hand truck. And so if that falls off the wheelbarrow, falls off the hand truck, falls off of the unloading of under the luggage and hurts the public, that's excluded. I mean, that's not excluded under auto. It would be covered. If it's unloaded by a mechanical device attached to the unit, meaning we've seen the block trucks with the crane which unloads the blocks it carried with the truck and unloads those blocks off of that truck with the crane attached to the truck, that's still auto. But if it's unloaded or loaded by a crane, a front-end loader, or a forklift, that's not auto. Again, that goes back to the GL because that's not excluded in loading and unloading under exclusion G in the GL. Even the forklift they take with them hung on the back of a flatbed to unload the sod or the mulch or the hay that's on the flatbed truck. As they run down the highway, if that forklift falls off, that's still auto because it's treated like any other cargo. It would be as they unload it and it falls off and hurts somebody next to it, that would still be auto. But when they use the forklift to unload those things, then that becomes GL. So let's look at some examples. Limitations of above: no coverage for damage done to the public during the movement of property by mechanical device. Excludes does not apply if the device is attached to a covered auto. Bodily property damage done covered by BA. Exclusion does not apply if movement by a hand truck. Business auto and bodily injury and property damage done covered by the business auto policy. Excludes applies only if the movement is by a device not attached to a covered auto. Crane, forklift, front-end loader. Coverage for the bodily injury and property damage then found in the GL of the owner of the device being used. So that's, again, where GL and auto works together. Let's talk about some examples. The insured is a beer distributor. The driver takes a hand truck that have been attached on the front of the power unit off, places beer cases on the hand truck, takes the hand truck load of beer into the 7-Eleven. On the way to the cooler, makes a left-hand turn down the aisle and runs over the legs of the customer, bending down to pick up the can of peas. The injuries to the customer's leg as our driver is taking that hand truck load of beer to the cooler, even though the vehicle is 1,000 yards or 100 yards away or 100 feet away from the entrance of the 7-Eleven. Is that auto or GL? Insured is delivering their legal grass, sod, to a job site on a flatbed trailer. There is a forklift attached to the back of the flatbed. On the way to the job site, the forklift falls off and hits a car beside the trailer. Also damage to car and passenger. So the forklift mobile equipment falls off the back of the flatbed being transported. The injuries done to the car, the passenger in the car, is that auto or GL? Same sod delivery truck, but truck makes it to the job site. Forklift didn't fall off. While unloading the forklift, it becomes unbalanced and falls from the trailer and hurts an employee or customer. The damage to that employee of the customer, is that auto or GL while they're unloading the forklift? Same sod delivery truck at a job site. Gets the forklift to the ground and unloads a pallet of sod. While unloading, runs over 2 mailboxes with the forklift, one of which falls on a car parked in the driveway. When hitting the mailbox, an oil line is split and oil drops on the driveway, damaging the asphalt. Is that auto or GL? Insured's a block truck company. They carry blocks on a flatbed attached to the power unit. They also have a crane attached to the power unit to unload the blocks that is on the power unit. While using the crane, a load of blocks becomes unbalanced and falls, hurting an employee or the customer. Is that auto or GL? Unloaded with a device attached to the unit, unloading what was on the unit. Auto or GL? Here's the answers. First example of the beer being delivered. It's auto until the beer gets to the cooler being delivered by the hand truck. When it gets to the cooler, and then if they stack it up and fall down, it becomes GL. But even though the vehicle is parked 100 yards away from it, it's still auto because we're unloading it by hand. It's not the final destination. Forklift or other mobile equipment being hauled or towed, if they fall off or becomes unattached and do damage, that's still auto liability. It's treated like any other cargo. No coverage for the equipment, but damage done by the equipment when it falls off. Same as above. Even if stopped while the forklift's being unloaded, it's still auto. However, it's GL when the mobile equipment is being used to unload, meaning once we get the forklift on the ground, start unloading the sod, and then run over the mailbox, damage the mailbox hits the car next to it, the oil leaks, then all that becomes GL coverage. 5, crane attached to auto carrying what is being unloaded. Again, that's auto until it gets to the curb, and then if it falls off later, it's GL. I point this thing out just to remind you that in all possible, when there's any potential loading unloading, you need to have the auto and GL with the same insurance carrier. So it's not a question of coverage. It's a question of what loss line is they're going to charge the claim to. There's many examples, but this is where auto and GL works together. And so what you find that's excluded in exclusion 7, handling property, 8, mobile equipment of the auto, is addressed or is not excluded in GL on the definition of loading and unloading. Bodily injury property damage arising out of the operation of any equipment listed in 6B and C. Those are the cherry pickers, the street sweepers, and the pump out trucks of the definition of mobile equipment, or machinery or equipment that is owned, attached to, or part of a land vehicle that would qualify under the definition of mobile equipment if it were not subject to compulsory or financial responsibility laws or the motor vehicle laws. This is that mobile equipment. What we talked about is that the crane, the farm equipment, the drill rig, they're usually operating only on the site, but they move from one site to the other. When they're moving from one site to the other, and if that movement's on public roads and it's self-propelled, then most states require that crane, that farm equipment, that drill rig to be tagged. So on the highway, it's auto, but once that crane gets to the job site, puts the outriggers down and starts unloading the trusses, unloading the signs, what's on the hook. If then it falls off of the hook and damages the public, then that becomes GL. Again, if you have the kind of equipment, why it's on the highway, then it's auto, but once it gets to the site and being used as a cherry picker, as a street sweeper, as a pump truck, as a crane, as mobile, as a drill rig, as farm equipment, start being used, then it becomes GL. Again, another reason to have auto and GL with the same carrier. So definition of coverage between GL and business auto. The point here is your insurers don't know the difference. Your insurer doesn't care. They just want to make sure they're covered. To be covered, you need to make sure that you have, that these insurers have GL, and preferably with the same insurance company. Bodily injury property damage done during operation of equipment of a defined auto with the following equipment type. Items defined as auto in B and C, while equipment is being operated only item C, B, and C. General liability coverage operation, business auto road exposure. Those items can move on land with rubber tires as well as roadway. While on the road it's auto, while stopped it is, and being used is GL. Complete operation. Bodily injury property arising out of, again, auto excludes this, arising out of your work after that work has been completed or abandoned. In auto, the work is delivering of something. In this exclusion, your work means work or operation performed by you on your behalf and material or parts, equipment furnished in connection with the work. But in auto, we're moving property. So what we're talking about, once the property gets to the final destination, the horse gets in the barn, the beer gets into the cooler, the concrete blocks get on the side of the curb, and then if the beer that was stacked in the cooler, if the blocks fall down, then it becomes GL. This gets back to the exclusion 7 when it gets to the final destination, then the auto quits covering it. So as we leave it there, but this also takes it, if it falls down sometime later, then it will not be auto GL, even though it was being unloaded and auto while it was being unloaded. Again, exclusions 7, 8, and 9, and 10 have to do with how auto and GL works together. So complete operation conforms with GL coverage. Movement complete, no more. Coverage under BA, coverage under GL. The BA form has no complete operation coverage. Horse in barn, gate not latched, horse gets out, that's GL. Beer in cooler, stacked too high and falls, again, that's GL. Blocks on the curb, falls and hurts someone, again, that's GL. Loading. Liability forms cover all operations, not excluded or activities within the definition. The general liability policy, exclusion G, excludes operations of autos, owned, operated, loaned, or rented to others, and operation including loading and unloading. So loading and unloading are not covered. So that's how they work together. Let's go back to the insurance agreement, and we're going to focus on the second paragraph here. Again, we pay for all that sums as insured legally must pay as damage caused of bodily injury or property damage to which this insurance applies, caused by an accident and resulting from the ownership, maintenance, and use of a covered auto. We will also pay all sums that insured legally must pay, so therefore, as a covered pollution cost or expense to which this insurance applies, caused by an accident and resulting from the ownership, maintenance, and use of the covered auto. So the key part here is paragraph 1's direct damage, but it must be an insured must be liable. That means that we do the name insured properly, and it must be caused by a covered auto or sim was done. The second paragraph addresses covered pollution cost cleanup expense, and that would be the second paragraph, and that it would be the cleanup expense. But again, it must be, our insured must be legally liable and must be covered by a covered auto. So when we're looking at property damage coverage as related to bodily property damage, pollution damage coverage found in the first insurance agreement when not excluded. That's direct damage and loss of use. Cleanup of pollutant. The auto coverage form has an insurance agreement to assume cleanup by an insured under a definition of covered pollution cost and expense. So when we think about an auto hauling something, there are three areas that the pollution could come from. The property that's being hauled, the property that's insured care, cushion, control. The property could fall off. Your insured could have on the back of their pickup truck a 55-gallon drum of oil. They could go over one of the speed bumps. That 55-gallon drum of oil could fall out of the back of that pickup truck. They could hit a vehicle on the road, and that vehicle on the road could run over that 55-gallon drum, damage the front end, have the driver head hit the windshield. But as they did that, the oil could have escaped that was in the 55-gallon drum and also hurt the driver, damage the paint on the car, causing the car to slide down the highway, turn over, and the fluids of the car could have escaped, the gas in the car. The oil could have also got to the pickup truck, causing the pickup truck to turn over as they 55-gallon and causing the gas in the pickup truck to fall over. So we have this 55-gallon drum being carried down the highway. It falls off. It hits the car next to it. That car next to it gets damaged. The person inside gets damaged, causing the drum falling off. But what was in the drum escapes, causing the car that the drum fell onto to have a further crash, causing its gas to the gas in the fuel tank to escape, and causing the carrying vehicle, our insured vehicle's car, to escape and its to turn over and its gas to escape. So this is what we're talking about. Property used to service the vehicle, that's the gas in the vehicle, and property that is someone else's property, that would be the gas in the car or the vehicle we hit. So we have property being carried, does damage, 55-gallon drum falls over. Property used for the insured for service of the vehicle, the gas that is in the unit that was carrying the 55-gallon drum, and the fluids that are in the car that the 55-gallon drum hit, and that gas lead fell off. This is where you have the exposures. If you look at definition G or L in the policy, a pollutant is anything that's yucky. Here's the definition. We can look at it all day. For the sake of time, I'm going to the bottom line. The bottom line is, this is pollution direct damage. This is exclusion 11 in the policy. We exclude bodily injury property damage, but not if it's from the cargo. We do not exclude it if it's from the fluids that make the vehicle go, or we don't exclude it if it's other people's property. So when the 55-gallon drum escaped and that all caused damage to the driver, we would not cover that. We do cover the fluids that came out of the vehicle that was hauled in a 55-gallon drum, and we do cover the fluids that was in the gas of the car that we turned over, but not the damage to the driver. The cleanup, cover pollution cost and expense, because once we have all the oil on the ground, we need to clean everything up. And again, the same concern here is when we look at the same coverage here. We do not cover, bottom line here, this is cleanup. We do not cover the cleanup if the cargo cost it. We do cover if the fluids for the service of the vehicle covered, and we do cover somebody else's property covered. So the concern we have here is there's no coverage pollution damage done under the exclusion in the form as also under the covered pollution cost and expense if it's our insured cargo. We do cover pollution damage done if the fluids for the vehicle escapes. That's the diesel fuel, the gasoline, the hydraulic fluids, the battery acid, those things is covered. And we do cover it if our insured caused someone else's property to escape. One of my insureds were hauling a program we had in Florida for harvesters, took a tractor trailer into a orange field, dirt orange field, ran over a hose. That hose was connected to 1,000 gallons of a tank with 1,000 gallons of herbicide. When our insured ran over the hose, it split the hose, causing the herbicide to escape into the ground, and we had to pay $65,000 to clean that up. That's somebody else's property our insured caused to escape. So we have exposures for pollution being hauled, and that's the key part here. If our insured is hauling anything pollutant, oil can be pollutant, battery acid can be pollutant, any kind of paint can be a pollutant. So there's a lot of things that can be a pollutant here. If it's our cargo, then there's no coverage. If the fluids to make the vehicle go, there is coverage. If property damage of others cause it, it is covered. So that's how exclusion 11 works. Exclusion 12, we do not cover bodily injury property arising on a direct or indirectly of any war, including declared war. So we worry about our insureds using vehicles in war. Again, not much exposure for most places. I use facetiously, except in Miami and a few places like that. But we don't have war. We have war exclusions in the auto liability policies and general liability policies and other policies to conform with an old tradition for reinsurance, mainly out of the Lords of London, which won't reinsure any policy without a war exclusion. We don't cover racing. Covered auto while used in any professional organized racing or demolition contests or stunning activities, or while practicing for such contest activity. This exclusion also does not apply when the covered auto is being prepared for such a contest. Racing is an organized racing. It's not your insured sitting next to a stop sign, revving up the engine, and say, I can beat you to the next stop sign. It's if they're dealing with racing, and we don't want to cover those autos involved in it. And so, again, that would be particular coverage where we cover race cars. We just don't cover that activity. So, the exclusions you need to watch. Exclusion to watch for and make sure there's coverage other than auto coverage from contractual to coverage as an insured contract. All contracts except physical damage autos are rented autos, railroads and trucking. So even though we exclude contractual, it's broad form contractual because all we really exclude is the physical damage covered to a rented or leased auto or auto that's borrowed by your insured. We buy that back with hired car physical damage. We don't cover construction or railroad. We buy that back with railroad protective. And we don't cover trucking arrangements where our insureds use owner operators or our insureds haul for someone else. That's not contractual. We cover that by writing the motor carriage form, which addresses those contracts and those exclusions in the motor carriage form, which is designed to cover the trucker, the for-hire trucker. Work comp. We coordinate the work comp policy with the auto liability. If our employee gets injured, that's covered by work comp. And contained in that work comp act is a tort immunity exclusion, which says the employee cannot sue under auto liability, or excuse me, general liability, under tort. So we want to make sure everybody that works for your insured has work comp to put that in. If for some reason they don't have comp because the state does not require them, they misclassify the employee as an independent contractor, that employee gets hurt even though the state does not require work comp, or because they misclassify it and they sue our insured as an employee, the auto policy would not respond. And since there's no work comp in place, the insured is standing alone with no coverage. Yes, the worker has to prove negligent. Again, it's hard to do an auto liability than general liability to come up with some examples. The example of an employee using a poorly maintained vehicle is a very prime example where the employee notes that to the employer and the employer refuses to fix it, causing an auto accident, so the employee then sues. Work comp's not in place because Florida doesn't require you to have comp until you have more than 5 employees. You only have 4, so therefore there's no comp because it costs too much. And now that employee sues the company for the company negligence. There's no coverage in the auto liability form for that injury. The employer would have to pay out of their pocket, and if it's bad enough, the employee could own the company. We don't cover anything in the insurance care, custody, and control. Again, you buy that back by buying a cargo policy or by buying hired car physical damage if they're leasing, borrowing other people's vehicles. Exclusion 11, we don't cover pollution. Damage done by cargo, no coverage. Cover for fluids and other property is covered, or other fluids to make the vehicle goes covered, other properties not. So we don't cover if your insureds are hauling anything that's hazardous as cargo if the cargo escapes. We buy that back by adding endorsement C9948 that we'll talk about later. Make sure if loading and unloading done by the insured, make sure they have GL. By hand truck, anything attached to it is auto. But once it's delivered and falls off, then it's GL when it gets to its final destination. If it's being unloaded by a forklift, a forklift, a front-end loader, or a crane, then it's GL doing the loading and unloading. So you want to make sure if insured uses any kind of mobile equipment that they have a GL policy. That's the end of this presentation. We look forward to seeing you in hour 4.